I would like also to thank Ferenc Model Institute for the opportunity and honor to be a part of this great project, and especially Professor Szilágyi, who came back to hear our presentations. My presentation is about religious education in the public sphere in Slovenia, although I am from Croatia. But I think I did a rather fair research, and it is a rather different setup than we heard so far, because Slovenia has, I will say, multiple times took its own path and developed a rather different model of state-church relations. But when we come to religious education, we talk about education, we talk about schools. And one cannot stress enough the importance of schools and education, as they are one of the main mechanisms of socialization for people. Schools exist in a specific social and historical context that significantly designates it. Educational programs in schools are determined not only by general result of development of basic human knowledge, but also, and this is very important, by tradition and culture of a particular society. Most European countries do provide some kind of religious education, mostly confessional, but there are those who deliver religious education in a form of religious culture. However, religious education is sometimes a hotly disputed issue, where area of education runs a high risk of either to remain or to become a battlefield for ideological disputes. Slovenia is among the few European states which does not have official religious education in public schools, but there is only one elective, when elected, an obligatory course, Religion and Ethics, which is taught in higher classes of primary and secondary schools. It is interesting to mention that the Slovenian law, Organization and Financing of Upbringing and Education Act, explicitly prohibits any religious activities in public schools. Not only that, it also prohibits any other kind of denominational activity in public schools and kindergartens. This is why some scholars like to put equation sign between Slovenia and France with regard to education. It is interesting, therefore, to provide for an analysis of Slovenian legal regulation of religious education in public schools, which differs from the one in private schools. I would like to make a brief historical review, because I feel it is important for understanding the development of Slovenian way to regulate religious education. Before the Second World War, religious instruction was not only an obligatory school matter at public schools, but is also regarded as base and crowning of public education. Historically, in Slovenia, the Catholic Church and the Evangelical Church of the Augsburg Confession made a great historical contribution to the development of schooling system in Slovenia. During Austro-Hungary and the subsequent Kingdom of Yugoslavia, the religious communities had a strong influence in education. It was an obligatory subject, and religious communities enjoyed the exclusive right to implement it. Especially in Austro-Hungary, Catholic Church, of course, enjoyed a privileged position. However, the political transformations which occurred at the end of the Second World War and the creation of a new socialist Yugoslavia resulted with a conflict pattern of social secularization. In this system, the separation of state and church could not have been neutral. The communist Yugoslavia introduced a strict separation of the church and the state, an atheistic and materialistic ideology based on Marxism, and a systematic and constant oppression of religion and believers. Therefore, throughout the communist era, religious education was banned from public schools, as was religion from the public sphere. After 1952, religious education was completely banned and expelled from schools. In 1954, the Catholic faculty was expelled from the University of Zagreb and in Ljubljana. After 1991, the Democratic Republic of Slovenia enacted its new constitution, and that constitution marked a departure from the negative perception of religion and initiated a search for new foundations of church and state relations. However, as I already said, the path Slovenia took did not resemble the path that most other former Yugoslav republics took. They all opted for the separation of church and state, but with strong ties with the most numerous religious community. And Slovenia envisaged its own state-church relations model, which can be, although it is not legally prescribed as such, linked to the famous French model of laïcité. When Slovenia declared independence from Yugoslavia in 1991, the initial decision of the state was not to regulate the relationship between public school and religion. Subsequently, the Ministry of Education published the White Book on Education in 1995, and this document highlighted the concept of starting point and stressed the key goals of the reform of school organization and curricula. The result was the 1996 Education Act, which I already mentioned, which introduced the autonomy of the school space, with explicit prohibition of religious education. We can say that in theory and practice, three general models, as already has been discussed, exist. The model of state and or national churches, the cooperative or the concordant model, and the model of strict separation of state and church. Of course, these three are not the only pure models. They can be combined and elaborated. Slovenian model of relations between the state and the church is established by Article 7 of the Constitution. It is said in their legal theory that equality of religious communities has been, at least at the end of the first half of 2000s, understood by the state as an undiscriminating affirmation of the whole religious field. The meaning of this was that different religious communities are equal before the law. Most feel that Slovenia has the French model of laïcité and that the principle of separation establishes the secularism of the state. This means that the state must not be tied to any church, and it cannot privilege, discriminate against, or opt for religiosity or non-religiosity. The principle of separation of state and religious communities is predominantly understood and interpreted in terms of consistent and strict separation modeled on state, with more pronounced separation of state and church. Such position is not to be attributed to the constitutional order, but legal and executive derivation of this constitutional principle, and in particular the influence of the previous political system. Slovenian authors agree that Article 7 of the Constitution prescribes three principles which define the legal position of religious communities: principle of separation, of free action of religious communities, and equality of religious communities. However, the Religious Freedom Act, which was introduced in 2007, in accordance with Article 5 of the Constitution, regulates the duty of the state to respect the identity of religious communities and to uphold open and continuous dialogue with them while developing forms of permanent cooperation. Principle of separation does not prevent religious communities to freely pursue activities in their sphere. Indeed, the separation of state and church does not require, in the spirit of European political culture, nothing but that the authorities do not use religion for their own intentions, and that religion does not attempt to abuse the state to achieve its own objectives. In 2007, as I already said, Slovenia's parliament passed the Religious Freedom Act with a majority of a single vote. It was very hard to pass this law. The impact of the Religious Freedom Act on Slovenian model of state-church relations is huge, as it marked a sharp turn in practice and legislature. Namely, prior to its enactment, Slovenia was rightly portrayed as a country which mirrored France in its laïcité model of state-church relations, which strongly insists on state neutrality. The legislator not only embraced the idea of French secular school or the United States of America's model, but surpassed them by introducing an ultra-strict model of separation of religion and state and school, which is quite different from that of the majority of European countries, where the laws guarantee religious instruction within the framework of public school. After the enactment of the Religious Freedom Act in 2007, Slovenia undertook a huge change, as it embraced, in reality, another model of state-church relations, the cooperation model, in which state neutrality cannot have the same significance as it did in the earlier model. Moreover, according to the Religious Freedom Act, the state is obliged to enter into relations with various religious communities. However, the state entered into such relations with religious communities even prior to this time. There are 3 agreements in the early 2000 and 2002 with the Holy See. This would suggest that the model of state-church relations in Slovenia was never really one of laicite. Namely, the Education Act explicitly, as I said, prohibits any religious activities in public schools. Not only that, it also prohibits any other kind of denominational activity in public schools and kindergartens. It was enacted in 1996 and established the autonomy of schools, when the state assumed the obligation of neutrality and tolerance and of conducting activities that are non-indoctrinating and non-proselytizing. The law forbids religious activities in public schools, which in practice means that it is not allowed. 1, to perform confessional religious education, teaching in classrooms. 2, to have teaching contents or teachers appointed by religious communities. And 3, to organize religious services in schools or kindergartens. Therefore, religious education in public schools in Slovenia does not stricto sensu exist. In the famous case of Mihaljarc et al., the Constitutional Court reviewed the question whether the provisions of the Education Act interfere with the positive aspect of freedom of religion, the principle of equality, right of parents, and the right to free education. The court first declared that the general prohibition of denominational activities in public schools is not inconsistent with the Constitution and the European Convention. The only inconsistency with the Constitution was the prohibition of denominational activities in licensed kindergartens and private schools in regard to denominational activities which take place outside the scope of formal education. So, the execution of a valid public program financed from the state funds. The court instructed the National Assembly to remedy the established inconsistency in a time limit of 1 year, and the legislator consequently changed the provision of Article 72 of the Education Act by allowing the licensed kindergartens and schools to carry out denominational activities which take place outside the scope of the execution of a public service. So religious education is not deemed a public service. Confessional activity encompasses the following: religious or confessional instruction of religion with the aim of educating for that religion, lessons on content, textbooks, teacher education, and suitability of an individual teacher for teaching decided by the religious community, and organized religious rites. In this way, presence of religion is completely expelled from a public space, a school. Therefore, the court took the path which placed the Republic of Slovenia on the extreme edge in the comparative framework of European countries that the doctrine describes as countries with unfriendly or intolerant models of separation. One should also bear in mind that this decision, Mihaljarc et al., dates from 2001 and the Education Act from 1996. The emphasis on state neutrality was significantly stronger than it is now, as can be shown from the decision in which the court in 2008, when deciding on the constitutionality of the Religious Freedom Act from 2007, said, that, which was quoted already, that in conflict between positive and negative freedom of religion, that is, when positive freedom of religion interferes with negative freedom of religion, negative freedom has no a priori advantage over positive freedom. This means that the right of unbelievers not to be confronted with a religious belief and consequently also with religious symbols does not always and automatically has precedence over positive religious freedom, which represents freedom of believers to profess their faith and to testify it publicly. The significance of the Religious Freedom Act for the Slovene state church model was already discussed, as it in reality modified it towards the cooperation model. A very interesting question linked with religious education is the question of public funding of private schools. The question is a very hotly disputed issue in Slovenia, politically, ideologically, financially, whatever you want. There has even been an initiative in the Parliament in November 2017 to amend Article 57 of the Constitution in such order to ensure that only public schools receive public funding. The initiative was voted with 60 votes in favor and 22 votes against out of 90 members of the National Assembly, but the constitutionally prescribed majority of two-thirds was never achieved, so the Article 57 remained the same. Some parliamentary parties were, of course, strongly opposed to such action, which would lead that private schools cannot be funded with any state funds, and private schools are mostly religious ones. So those parliamentary parties argue that the initiative is prompted by ideological reasons only. It is necessary in this regard to mention two other decisions of the Constitutional Court, the one from December in 2014 and the subsequent decision on the same matter from March 2020. In the first decision, the Constitutional Court found first sentence of the second paragraph of Article 86 of the Education Act not in accordance with the Constitution. The result should have been full public funding of private schools, and the court gave the National Assembly 1 year to rectify the situation. However, the state did not do anything about it for 5 years, and then in 2016, a group of petitioners instigated the procedure in front of the Constitutional Court to force the government to enforce the earlier decision from 2014. However, the court, in a somewhat Copernican twist, ruled now that the constitutional provision is in accordance with the Constitution. The court found that the extended part of the program of a private primary school does not correspond with the program of public primary schools and is not compulsory. This means that the constitutional obligation of primary school education of pupils in a private school providing officially recognized program refers only on those contents of the program which correspond to the contents of compulsory work enshrined in a program of public primary schools. Therefore, only such part of the program of private schools should receive 100% of public funding. In the aftermath of these decisions, the National Assembly amended the Education Act in June this year. Prior to this amendment, rather extensive public debate about necessary changes in the Education Act has been going on. The amended Article 86 prescribes that private schools shall receive 85% of the funds provided by the state or the local community for the implementation of the public school program. However, in addition to the 85% of funds, a private school providing officially recognized program shall be funded from the state budget or the local budget, but they are always underfunded for 15% for morning care, extended stay, and religious education. Religious education is, of course, not funded in any way. It is rather self-evident that the state does not want to fund any part of the curricula that is not the same as the curricula in public schools. One could even say that it would appear that the reason for opposing full funding of private schools is in reality ideological fear of religion. This because then the state would have to fund even religious parts of approved curricula in private schools. Although, as was mentioned, religious education in Slovenia does not exist in public schools, there are, of course, some elements of it in other subjects. For example, subjects such as history, philosophy, literature, arts, language classes, and so on, as teaching about religious facts is a part of curriculum of such subjects. There are also subjects religion and ethics and civic patriotic education and ethics. The former is facultative and a pupil may elect it in the last 3 years of primary school and is non-confessional. And the latter is compulsory and takes place in the 7th and 8th year of grammar school. Also, in the area of upper secondary education, the subject religion and ethics remains an optional subject. Therefore, both subjects were not, however, both subjects were not successfully implemented, and some argue that only a small number of pupils in reality receives a systematic religious education. From the above stated, it is obvious that Slovenia chose a rather different approach to religious education in public schools, originally in 1996 even in private schools, in comparison with all other ex-Yugoslav republics. As was mentioned, all other Yugoslav republics reintroduced religious confessional education in public schools and opted for the cooperation model. Slovenia, on the other hand, opted for an extreme approach to the question of religious education in public schools, introducing strict separation model of religion and state and school. This approach is, I would dare to say, unusual by European standards, as religious education is present in almost all European countries. Mostly confessional, with some countries opting for religious education in the form of religious culture. Slovenia is in a relatively small group of countries with France and Albania, and France has already mentioned exceptions in historical regions because of historical reasons, which do not have any religious education. Of course, as mentioned above, it did introduce some elements of religious education through other courses. and there is the subject religion and ethics as an optional subject. However, there are problems with the implementation of said subject, as only a small number of secondary school students receive such education. Therefore, it must be concluded that religious education in Slovenia is almost non-existent. This is because, especially in the 1990s, Slovenia took the stand that there must be strict separation of state and church. However, after coming into force of the Freedom of Religion Act, the situation is not as it once was. Therefore, maybe it is time to rethink the position of religious education in Slovene public schools. Some argued that there must exist, I would say at least, some obligatory topics regarding religion and ethics in school curricula, and some optional ones. It is, in my opinion, impossible to introduce pupils to such topics through other subjects like history, arts, and so on. This means that most pupils in Slovenia do not have adequate knowledge about, inter alia, major world religions, religious culture, religious freedom, and so on. This is why I argue that such an obligatory subject should be introduced in Slovene public schools. And perhaps most important thesis of mine is that one should ask whether today's legal regulation of religious education enables for the development of a pluralistic educational system as a whole. Namely, if there is no possibility to explore the vast topic of religion, not only confessional religion, but religion as a social construct and part of every society, how is it possible to ensure the existence of a pluralistic educational system in which all are equal and are equally respected? When we take everything said into account, except the fact that religious education or the right to it is a part of the freedom of religion, then the answer to the posed question must be no. So confessional religious education, as a concluding remark, would maybe be a step too far for Slovenia. But religious education in the form of religious culture should and would be a welcome addition in the school curricula in Slovenia. Thank you for your attention.